What lawyers learn about jurors that you never see? When we talk about jury trials, we spend a lot of time talking about evidence. What did the witness say? What did the forensic evidence show? Did the prosecution meet its burden? Did the defense create reasonable doubt? But there's another part of jury trial that we don't talk about nearly as much, the jury itself. Because 12 people can hear exactly the same evidence, receive exactly the same instructions from the judge, walk into the same deliberation room, and interpret what they heard very differently. I learned that very early in my legal career. In fact, I learned it during my first jury trial as a certified legal intern. After that trial was over, Judge Shoemaker told me something. He said he had almost decided not to tell me, but ultimately thought I should know. One of the jurors had a boyfriend who was facing criminal charges. His trial was the very next day. During jury selection, she had denied knowing anyone who had a criminal charge, who was facing criminal charges. But according to what the judge told me afterward, once she was inside the jury room, she was talking about how the state likes to bring the man down. Think about what that means. The jury was supposed to deliberate based upon the evidence admitted in the courtroom and the law they had been given. But one juror walked into deliberations carrying something else. Her own experience, her own belief, and information that attorneys hadn't been given an opportunity to evaluate during jury selection. That experience taught me something I've never forgotten. The evidence may stop when the courtroom door closes. Human nature doesn't. And later, my criminal law professor, Joe DeRocher, told us another story that reinforced that lesson. His wife had served on a jury. And because she was married to a criminal defense attorney, she apparently began explaining legal concepts to the other jurors. You can imagine why people might listen. My husband is a criminal defense attorney. Sounds like authority. Except according to my professor, some of what she was telling the other jurors was actually the opposite of what the law required. And that's when jury dynamics becomes fascinating. Because confidence is an expertise. Proximity to expertise is an expertise. And the person who speaks with the greatest certainty isn't necessarily the person who understands the evidence or the law the best. Every group develops dynamics. Some people naturally lead, some people naturally challenge, some people mediate, some people would rather avoid conflict. And sometimes one confident person can give everyone else a narrative that makes complicated evidence suddenly feel simple. But a compelling narrative isn't necessarily an accurate one. That's one reason jury selection matters so much. Lawyers aren't simply trying to find 12 people who agree with us. We're trying to understand how people think. Can this person follow the judge's instructions even if they disagree with the law? Can they recognize their own assumptions? Can they evaluate evidence that challenges what they initially believed? Can they disagree with someone who sounds absolutely certain? And perhaps most importantly, can they change their mind? Because that's something I think about outside the courtroom too. Especially when we discuss true crime, ask yourself, what evidence would change my mind? If you're convinced someone is guilty, what would make you reconsider? If you're convinced they're innocent, what evidence would challenge that? Because if the honest answer is nothing, then you're no longer weighing evidence. You're protecting a conclusion. And jurors can't afford to do that. Neither should we. A criminal trial isn't supposed to determine which side told the most emotionally satisfying story. It's supposed to determine whether the government proved the charged offense beyond a reasonable doubt. That requires evidence, it requires careful reasoning, and sometimes it requires something extraordinarily difficult. Being willing to admit that the conclusion you walked in with may have been wrong. The most persuasive person in the jury room isn't necessarily right. The quietest person isn't necessarily wrong. Confidence is an evidence, and justice should never depend on who can tell the most convincing story. It should depend upon what can actually be proven. Because at Grace and Gavel, we can care deeply about victims while still demanding fairness for the accused. Those principles aren't enemies. That's what justice requires. Thank you so much for tuning in to Grace and Gavel, where truth meets compassion. My name is Buffy. I'm an almost 18-year criminal defense attorney. Feel free to check out Grace and Gavel if you're interested. It's a true crime channel. And also feel free to like and subscribe if you got some value from this. Thank you so much and have a great rest of your day. I appreciate your support. Bye-bye.